All right, well, welcome aboard, everybody. Today we're here to talk about a community manager's role in construction defects and also talk a little bit about how to distinguish what's maintenance from what's defects. This course is approved by the CAI for continuing education if you're CMCA certified. So be sure to keep a log of this and we will send you a certificate after the presentation is complete. All right, well, here we go. We'll jump right in. Some of the considerations you want to keep in mind at all times when you're managing a community is always think about what the common areas are, what limited common elements, and what's individual responsibility at the community. The association obviously really only needs to be concerned about things that it is responsible for, either that it owns or that it maintains. You have to also consider the association's funding sources and its ability to pay for things, and consider the impact of any construction-related problems that a community might have in terms of the lifetime cost analysis. For example, if the walls are eroding due to sulfate attack at the bottom, where you see the deterioration in a CMU wall, that's going to dramatically increase the cost of maintaining that fence over its life and shorten its life as well. So those are things to keep in mind, not with respect only to fences, but all other parts of the community as well. So a lot of times construction defect issues first come up at the time of turnover, and it can just be as simple as some maintenance items that the developer hasn't done, or possibly there is no indication of any lack of maintenance by the developer, but still the incoming homeowner board members and sometimes the outgoing developer board members want to inspect the condition of the community and document it. The homeowners might want to know what they're getting into and what might need to be done or corrected. And the builder might want verification from an independent source that everything's in good condition at the time of turnover to try to limit its future liability. So considerations at this time, you want to look at how the property has been maintained, how old it is at the time of turnover, what maintenance is done, and what needs to be done. And there should be clear communication about these issues between the developer, its former board members, and then the incoming homeowner board members, and maybe even a new management company. And the association should consider what the financial impact of this is going to be. If things are in poor condition, obviously that needs to be reflected through reserve funding and allocation of money to perform maintenance and repairs. If things are in good condition, this might allow the association to favorably adjust its assessments or leave them the same for a while, depending on what a reserve study might say. Of course, at the time of transition, you're always going to do a reserve study. You should always do some kind of a transition study as well. There should be some kind of inspection of an association's common areas or common elements at the time the transition is completed, so that everybody knows what needs to be done, what's defective, and what might not be a problem in the future. There should also be a transfer of maintenance records. One thing that's important, obviously, is a reserve study. And in order to update that reserve study and do it properly, that reserve company is going to need to know what work has been done as far as maintenance and repairs go. So if no records are transferred at the time of turnover, then that reserve study company, when it updates the reserve study a few years down the road, it's not going to be able to credit the builder or the association having done any of that maintenance, and it's going to have to assume that no work has been done on the common areas. And that can make the reserve situation look more dire than it otherwise need to if that maintenance information had been passed along to the new board. So then we come up to the question then, okay, we've found some things that are problems in the community. Is it something that's just maintenance that needs to be done? Or is it a construction defect? And, to help try to sort that out, is there damage being caused by this? How much damage? What type of damage? How frequently is this occurring? How pervasive is it throughout the community? And, is it the after effect of a construction defect, which, generally speaking, is anything that doesn't follow the building code, the plans and specifications, or the manufacturer's installation instructions at the time of construction. Anything else is probably going to be maintenance. And then the big question, do you need to hire an architect, engineer, or an attorney? And do you perform repairs? Well, hiring an architect, engineer, and attorney are some of the best things that an association can do at this point. And it's one of the best things they can do for the manager as well, because then that takes so much of this load off the community manager. You don't have to be the one trying to answer these questions, and you'll sleep better at night if the association isn't looking at you to be the person who's answering these questions. If the board members are looking at you at a meeting and saying, is this reasonable maintenance or is this a construction defect? You might know. There are certainly managers who have been around long enough, and they have a sense as to what kind of maintenance that asphalt or some other building component is going to need. Or they can pick up the phone and call an asphalt contractor with whom they have a good relationship and ask questions and figure out more or less whether something is a defect or maintenance. But you're putting yourself out there and doing something that you don't necessarily even need to be doing, that you could be relying on other people for. And more importantly, the association can be relying on other people for, and just take that whole load off of your plate. So the reserve study, that's another type of an expert that you would want to involve generally at the time of turnover. Usually the builder gets a reserve study done at the beginning when they start a project. Most of them don't ever have it updated unless the project takes an inordinately long time to complete, which we've seen some of that in the last 10 years, projects that stalled around 2008 or 9, and then were built out, 2017, 18 kind of time frame. Here are some examples of, what you might typically see at the time of turnover here, where, you see a workman assessing the condition of a balcony where you have problems with the flashing and it not draining properly. And you can see, here's an example of water damage to a framing member. And, you look at this on the surface, this photograph doesn't look that bad. I mean, you can see the gutter's not even, and there's maybe a little bit of water damage in the bottom right corner there. But when you tear this apart, you see that structural member's in pretty poor shape. This is the type of thing that, it doesn't look like a big problem on the outside. You see all that rotten wood there. But these are the kind of things you can find in a worst case scenario on a relatively new building when you go and cut things open and start assessing the condition or the quality of the construction. This is OSB, oriented strand board. That flat product there, it looks like plywood, but it doesn't hold up like plywood. And when this stuff gets wet, it's pretty much ruined. You can usually pull it apart with your fingers once it's gotten wet. Here's some examples around a window. This is not the right way to flash a window. And you can see in the top right corner of the window there, where they have that building paper going behind the window flashing. That's not how it should be. It should be the opposite. It should be that the window flashing goes over that to help keep rain out of the building. Here's an example where you have a roof constructed improperly and you have all that wood rot on the OSB there on the vertical wall. Here's some issues you can see with concrete. I'm sure we've all seen asphalt like this, but sometimes you see this in projects that aren't very old. Anytime you have a vertical offset like this in concrete, that can pose a tripping hazard. That's obviously a bad thing. So that's just sort of a sample of the kinds of things that you can see in a community or that can be lurking out there that you wouldn't necessarily know about. And all of those pictures depict good reasons for a community manager to involve experts. And I'm not saying run to the phone and hire a lawyer, but you can certainly contact one and ask questions. Certainly you don't even have to call a lawyer, just contact some kind of a construction professional so that you can be confident as to whether or not problems exist. Is it worth pursuing? And you can get some kind of sense as to, on if we're talking orders of magnitude, is this a problem that's tens of thousands of dollars, hundreds of thousands, or millions of dollars? You also want to think about how the original construction is going to affect maintenance costs for the association long term. And here's an example, or, if you manage a high-rise condominium, I don't know if anybody here does that, but if you don't have a davit system that would allow workers to, be raised and lowered along the side of the building to wash windows and do other things, how are you going to replace the window sealant on that building? So the omission of the davit system doesn't necessarily cost the association anymore. It makes it a lot harder and more expensive, presumably, to wash the windows. But the difference in cost of doing things like maintaining window sealant is going to be astronomical for that association down the road. So while it doesn't cause damage, it's still something that you should think about as being a construction defect that should be addressed at the time of turnover. Now, of course, just because there are construction defects in a project, it doesn't mean that we're going to go rushing off into litigation or that the association should do that. The first step is going to be to do a study, have somebody go out there and evaluate the as-built condition of the project and document the condition of the common areas or limited common areas and make a presentation to the board. You want to evaluate the health of the project and just get a general sense as to whether or not it's a well-built or a poorly built project. And then you do your real expert investigation if necessary. That expert investigation might include things like intrusive testing, like the photographs that we saw a minute ago with the workmen pulling apart the patio to find out what was going on underneath the weatherproof membrane. That kind of limited testing can give an association a really good idea about the quality of construction and any resultant damage that may be occurring. But once you've gone through all of those steps, you're still not going to run off and file a lawsuit or anything like that. You talk to the builder, and every set of CC&Rs that's been drafted in Arizona in the last 20 years has some kind of an alternative dispute resolution provision in it. And step one in those is never litigation. There's also statutory regimes in Arizona that give developers the right to have notice and the right to go out and perform repairs before a community association or a homeowner runs out and files a lawsuit. So if we go back to the CC&Rs, like I said, they all have an alternative dispute resolution provision. There's a lot of commonality between them. Generally speaking, most of them call for the association to send a notice letter to the developer, which then triggers a right for the developer to perform inspections and repairs. But the developer is not obligated to do anything. So he has the right to repair, but he's not obligated to repair. Then the next step would be to negotiate with the developer for anything that he won't fix out of hand. And then your next step after that, if you can't resolve it through negotiations, you go to mediation. And a mediation is a situation where you hire a person to act as an intermediary and work with the two sides to try to get them to reach a negotiated settlement. It's something that you would do these days via Zoom for a day. And the mediator shuttles settlement offers back and forth between the builder and the association, and tells the sides about the strengths and weaknesses of their cases. That generally they focus on the weaknesses of your case to try to push you towards the middle to get it resolved. And then if you don't settle the case through mediation, the last step would be arbitration. Arbitration works like a trial. You have a judge who's called an arbitrator, and you have a hearing and you present witnesses and evidence and testimony, and the arbitrator makes a binding decision and you're stuck with it. Arbitration is different from litigation in that, in theory, it's supposed to be quicker and more efficient and less expensive. However, it doesn't always work out that way. And some of the problems with arbitration are that, in court, you have a judge. The judge is free. He's paid by taxpayers. And the arbitrator that you're going to have might charge $500 an hour. And by the time you go through an arbitration where you're filing motions and bickering back and forth about everything, that $500 an hour can add up to be real money pretty quickly. Not only that, but where the rules for arbitration are supposed to be more streamlined and efficient and allow for faster resolution than a court case, the way arbitrators often interpret those rules means that those cases often work out just like court cases. The arbitrator is probably going to be a lawyer, and he's probably used to doing things in court. And sometimes they want their arbitration case to look just like a court case. So instead of having limited discovery, where maybe you only do 2 or 3 depositions, the arbitrator might allow parties to do all the depositions they want. So arbitration really pretty often ends up being more expensive than litigation. Now, in addition to this negotiation, mediation, arbitration framework, CC&Rs include other provisions that the developer writes in there to protect itself from defect claims. Some of the other provisions that you will see will say things like the association cannot recover its attorney's fees. So really the HOA never gets made whole if it goes through this process. And almost universally, the association has to get the vote of its members before it can proceed with one of these actions. Sometimes you have to get 75% of the owners to sign off to approve the association, even sending the claim notice to start this process. Sometimes you have to get 75% of all owners. Sometimes it's 75% of the people who get off the couch and vote. And sometimes you don't need the vote until before mediation or arbitration. These CC&R provisions are complicated. They're written like stereo instructions. And most lawyers don't like trying to interpret these things. And as a community manager, this is just another reason why you shouldn't mistake your role as interpreting these provisions of the CC&Rs for the board members. You're naturally inclined to want to be able to answer all of the board members' questions and explain to them everything about how this is going to work, and don't let yourself get sucked into that. This stuff's complicated even for lawyers. I've been doing this for 20 years, and I'm constantly pulling out my clients' CC&Rs to check them 4, 5, 6 times at every stage of the game to make sure that I've got it right, because there's a lot of nuance in these things and there are a lot of ways to mess it up. And if you mess it up, the results can be kind of disastrous. So don't feel like you need to be all things to all people, and try to handle all these complex issues for your boards in the communities that you manage. So what should you do? Okay, well, let's say we start down this road, we send out the claim notice, we go through mediation, and we don't get this thing resolved. Well, this might surprise you. You should keep track of your time. You should bill it. And most of you have your video off, and that's fine, but by show of hands, if I could see you, I expect many of your management agreements would say something along the lines of, you bill X number of dollars per hour for special projects or something else for your communities. You should do that. And I know that community managers are afraid to do that because they're afraid that other people in the marketplace aren't going to do it. The boards won't like it. They will be at a competitive disadvantage if they bill the association for their time for screwing with this kind of stuff. But you know what? It's in the contract for a reason. And, I don't want to sugarcoat it. If you go down the road of one of these construction defect matters, to some extent, it's going to take up time. Some of these things can take up a lot of your time. Some of them aren't that big of a deal, but sometimes it ends up being a lot of time for you, and you should keep track of your time and you should bill it. And if you're afraid of the impact of that with the board members, that's something you can talk to the lawyer about. And, I'm not the only lawyer who's going to tell you this, but, if you're keeping track of your time and you want to build the association for it, well, you know what? I, as the lawyer, I am fronting the costs for the experts. I'm fronting the costs for all the destructive testing. So I'm paying tens of thousands of dollars to engineers and architects and contractors. A few grand worth of community manager time is a drop in the bucket. It's a legitimate cost of pursuing one of these cases because it's in the management agreement, and you're entitled to be paid for your time, and it can come out of the settlement at the end of the day. It's something that the law firm should advance, and you should get paid. And then at the end of the day, it comes out of the settlement when the case is resolved. So, hopefully, give that some thought, but, that has a potential to really change how one of these cases impacts your company, and it can turn it from a time suck into a revenue source. And, certainly rightfully so, right? I mean, it is going to be a time suck either way, but if you can monetize that, so much the better. Another part of the time suck is going to be document review. And in litigation, and let me tell you, not just in construction defect litigation, as you guys probably, most of you know, I do all kinds of litigation. One of our biggest challenges sometimes is getting association records out of the community manager. And it's because of the time suck factor. It takes a lot of time to go through and gather all of those records. Well, you can feel free to just sort of dump everything on the lawyer and let the lawyer sort it out. Drag and drop everything onto a thumb drive, send it to the law firm, and, let them sort the wheat from the chaff and figure out what's relevant and produce it to the other party in the lawsuit. I don't care what law firm you're dealing with or what kind of lawsuit it is. The law firm would probably be happy to have you do that. And, that saves you a lot of time and headaches because, frankly, if you're having to spend a lot of time screwing with document review, you're still managing the same number of communities. You still have all these other expectations of your time. And even if you get paid for it, it's not necessarily going to make your day-to-day life any easier. If you're a portfolio manager with 10 communities you're trying to juggle, just dump everything on the lawyer. Let him figure it out or her figure it out. So that's another way that we can streamline your workload if you have a law firm involved and you have the right kind of experts. You can also do that, any document, any photographs that you get, every scrap of paper that you can get from the builder or have access to is going to help the association over the long term, not just in construction defect things, but also keeping track of what maintenance has been done, what might need to be done, where the money has gone, things like that. And that can protect the builder as well, because they can show, hey, they did spend money maintaining the community in some cases. They did make investments for the association. There are time limits for these claims. And this is another aspect of the law in this area that's anything but clear. Basically, the time limit is 2 years from when you knew or should have known that you had been damaged to bring a tort claim. What's a tort claim? Well, negligence, breach of fiduciary duty, things like that. Those are called torts. Breach of contract claims and breach of warranty claims, that's really the meat and potatoes of construction defect claims. Those you have 6 years from when you knew or reasonably should have known of the defect. And then you have something called the statute of repose, which is the ultimate cutoff for a construction defect claim. That is 8 years. When the building is 8 years old, you can no longer bring a claim, period. Of course, there's an exception, like everything else in law. If the defect's discovered in the 8th year, then you get a year from the date of discovery. So it can be 8 years in 1 day to 9 years if you discover it during the 8th year. And again, it's a complicated mess. Don't try to sort this out on your own. Don't try to interpret that and advise the association. That's what lawyers are for. We're happy to help with this. Let us be the ones at risk and not you. One thing that goes with this is an asterisk. You have the time limits now, 2, 6, or 8 years. With litigation, it's easy. You're in a car accident, you have 2 years to bring your negligence claim. Because negligence is a tort. As we just said, you have a 2-year limitations period. So you're in a car crash, you got 2 years. With a construction defect claim, it's not necessarily that easy. Normally, you find the leaky roof, you got 6 years or until the building's 8 years old before you run out and file a lawsuit and you're timely. Well, these alternative dispute resolution provisions that we talked about earlier complicate that because they require you to give notice before you can file an arbitration claim. Well, you have to file your arbitration claim within 8 years after the building is complete. So that means that if you find out about an issue, you have to send the notice, depending on the CC&Rs, 3 or 4 months before the 8 years runs. So these provisions in the CC&Rs have the effect of shortening the limitations period. Because if you wait until the building's 8 years old and you send your demand letter, guess what? The statute of limitations is going to run. And if you run out and file an arbitration, it's premature because you didn't follow all the steps in the alternative dispute resolution provision in the CC&Rs. So we have these time limits, but they don't even give you the full story because you have to comply with all the shenanigans in the CC&Rs. You have to jump through all those hoops before you can even file the action to stop the clock from running. So again, just keeping on you more reasons to get lawyers involved in these things. You can also do things like trying to amend the declaration. Some associations have actually amended the CC&Rs to change these time limits to make them less favorable to the developer and more favorable to the association. Some CC&Rs say you can't do that. It's complicated either way, but again, that's an option that's out there as well. But the 2, 6, and 8 year time periods are statutory, so you can't change that with an amendment to the CC&Rs. There's also Arizona law that figures into these things. This is what I mentioned this offhandedly earlier, the Purchaser Dwelling Act. This is the statutory regime that gives builders the the right to notice and an opportunity to repair before a homeowner or an HOA files a lawsuit or arbitration, maybe. But this statute does stop the statute of limitations from running when you send the notice of claim. The provisions in CC&Rs don't say that. So this only applies if the CC&Rs are silent on this issue. So don't expect that just because the Purchaser Dwelling Act says the time period is told because you send a letter, that's not how it works under most CC&Rs. But under the statutory regime, you have to provide a notice by certified mail describing what the construction defects are in reasonable detail. And you'll need an architect or engineer to perform an investigation to allow you to describe the defects in reasonable detail. So this is just saying that the construction professional, that's the builder, whomever, has a reasonable opportunity to inspect the property. A few years ago, they changed the statute to broaden who it encompasses. It used to be that this would only apply to the builder. the developer and the general contractor specifically. They were the ones who had the right to notice and an opportunity to inspect and repair. They've broadened it, though, to include professionals like architects and engineers, and the developer and general contractor now statutorily can drag subcontractors into this process as well. So once the developer or the general contractor get your notice letter, the association's notice letter, they have the right to inspect, and then they can make a written settlement offer within 60 days. The offer can include money. They can just say, we'll pay $100 grand to go away, or maybe they'll offer to perform repairs. And that's supposed to be in reasonable detail as well. And they have to give you a time estimate as to when it's going to be done. They can also offer you some kind of a combination of repairs and money. If they offer repairs, the HOA has to allow them a reasonable opportunity to complete the repairs. You can reject an offer of monetary compensation, but you cannot reject an offer to repair. You can tell them you don't want them to use the same subcontractors who built the place, but the Arizona legislature has taken away your right to tell the builder, no, you're a knucklehead, you don't know what you're doing, I don't want you to fix this because you're just going to make it worse. You have to let them perform repairs if they offer to perform the repairs. Now we talked before about the alternative dispute resolution provisions that are so common in CC&Rs. And, the CC&Rs require it. You have to go through the steps of notice, mediation, and arbitration. You've got to get the vote of the homeowners. And then one thing I didn't mention before, I did say that the CC&Rs include other provisions that are harmful to the association and protect the building. And I said, usually they will say that the association cannot recover its attorney's fees. Also, what they will do is say that you cannot recover consequential or punitive damages. Punitive damages are money damages that are intended to punish wrongdoers. If you think of the classic example of this, it's, when Ford Motor Company built the Pinto, and they had a tendency to catch fire or explode if they were rear-ended. Instead of recalling the Pinto and redesigning the fuel tank or putting cushioning around the fuel tank, Ford decided it was cheaper to just pay the families of the people who were killed in Pinto accidents. And ultimately, they were sued and they had to pay punitive damages for that bad act of prioritizing profits versus actually recalling the Pinto and solving the problem. You're not likely to find a construction defect case under Arizona law where there would ever be punitive damages. I just can't imagine any set of facts that would rise to that level. Now, consequential damages, that's different, and that can be a big deal for a community association. Consequential damages are those that reasonably follow from a breach of the contract. Let me back up and I'll tell you, direct damages are the simple damages. You have a construction defect, the roof leaks, it causes damage to the drywall, and your direct damages are the cost of repair, the cost of repairing the damaged drywall and repairing the leaky roof. Consequential damages are those things that are sort of the next step removed from that. So if you think about things like having to move your furniture out of that bedroom so that they can replace the drywall and the ceiling, you got to pay a mover to do that. Maybe you have to put your stuff in storage. Maybe there's mold, so you have to remediate the mold. Maybe you have to go live in a hotel for a while. Maybe it's a rental unit and you're going to lose rent because your tenant moved out because of this bad roof leak. All of these things are consequential damages. And they're something that is foreseeable to the developer. If they build leaky roofs, these things could all happen. That's foreseeable. And therefore, normally under Arizona law, you would be entitled to these types of damages. But the way the developers write these CC&R provisions, you can't recover those type of damages. The association has waived those damages. The developer wrote these things and they wrote them as board members of the HOA, but they didn't write them to be or to reflect the association's best interests. They wrote them to protect their own best interests. So, these are other examples of provisions in these CC&Rs that are actually harmful to the HOA, but yet most Arizona courts are probably going to enforce, because the judge is going to sit on his bench and look down at his nose at you and say, well, you could have bought somewhere else. So rather than try to navigate through this complicated mess yourself, you need to get help. First thing you want to do is to consider retaining an independent architect or an engineer or even a good general contractor that does not have a relationship with the developer. Also, right at the beginning, you might want to consider retaining counsel to give you advice on some of the legal aspects here and to just help you navigate it. The most important thing is going to be the architect or engineer. That construction advice is going to be the most important thing, because then they're the ones who can tell you if there's even an issue. You might have an architect come out and say, oh no, the cracks in the asphalt are all caused by temperature changes, and all you need to do is seal the cracks and get on with your life. And by the way, you should do that every few years anyway. Maybe that same engineer will come out and look at different streets and say, yeah, those causes in the cracks in the asphalt are caused by inadequate compaction of the substrate, and the streets need to be removed and replaced. And if that's the situation, I can assure you the builder is not going to want to pay that bill. So you're going to want to proceed with, retaining counsel and going through this process. But getting that construction advice on the front end will really let you know whether you need to do anything else at all. And when it comes time to hire counsel, you're all in CAI, I believe. You're all familiar with the construction defect lawyers. It's actually kind of a shrinking universe of people in the Phoenix area who do construction defect litigation. The ones who are doing it now are basically the same ones who were doing it 15 years ago, although some of us have changed firms. But you know who's out there, or somebody at your company knows who's out there who does construction defect litigation. You know that there's an option sometimes to have this done hourly or to pay a contingent fee. When is a contingent? Well, I think everybody probably knows what a contingent fee is. Just like in a car accident case, you get rear-ended, you go out and you hire Lewis and, or I can't even think of the names, Lerner and Rowe or somebody like that. They're going to do a contingency fee. They're not going to charge you, and they'll take a third of whatever the settlement is. We do the same thing in construction defect litigation. We do contingent fee work because, the attorney's fees for this stuff can run into the hundreds of thousands of dollars, and there aren't too many associations that can afford to pay that hourly. And some of the law firms, including ours, depending on the case, we'll do the work on a contingent fee basis. We'll advance the cost for the association, and then we get paid at the end, from the settlement that's ultimately recovered. We also do stuff hourly. Some of the law firms that do construction defect litigation don't do the cases hourly, but we will do that. I think there might be other law firms who do it as well, but we definitely do for the smaller things. And then one thing that you'll want to keep in mind is the great conundrum when we're doing these cases is, what does the fee agreement say about a repair-based settlement? And this is one of the areas where some of the firms are different from others. And you might want to think about, if you think that your community's builder might actually perform repairs, or that your board members might actually accept an offer for repairs, after the statutory period, how is the attorney fee going to be calculated based on that repair-based settlement? Because some of the firms will just say, oh, look, my contractor says those repairs are worth $10 million, so you owe us $3.33 million because you accepted the repair offer. Sometimes, and what our firm has done in the past is we've talked to the association about, what could specifically happen in this case, and, what the association's board and the law firm think would be a fair and reasonable way to calculate the fees if you end up resolving the case through some kind of a settlement, a repair-based settlement. So that's one thing to think about and talk to the lawyer about when you're negotiating the terms of the fee agreement, to ensure that if there is a settlement that includes repairs, that the law firm's fee on those repairs is going to be reasonable. Because sometimes you get in a position where the association, after the statutory period where the builder no longer has the right to force repairs, but you get down the road and the board members would be happy or willing to accept a repair-based settlement offer, but they can't afford to do it because they would have to come out of pocket to pay the law firm attorney's fees for getting the case to the point where this good repair offer is at least being made. So that's one thing to consider as well. I will also tell you that depending on what law firm you talk to about construction defects, there are guys out there who are salesmen and who don't actually practice construction defect law in Arizona. And, I think many of you know me, but I'll tell everybody in case you don't know me, I am a litigator. I do the cases. This is what I do for a living. So if you hire us on a construction defect matter, I'm the guy you're going to be working with. I'm not a salesman. As you can probably tell from the presentation today, I work with the clients on the construction defect cases. Thank you very much for taking time out of your day today. And, I look forward to working with you all in the future. And if any of you have any questions, no matter how big or small about construction defect matters, please, feel free to pick up the phone and call. I'm not the guy who's going to say, oh my God, this is a huge problem. We need to get out there and do a full investigation and tear apart the community and sue the pants off the developer. That's not me. So if you have any questions about any of this stuff, feel free to pick up the phone and call or shoot me an email. And I will give you helpful, useful advice and counsel.